Hello, everyone, and welcome to today's webinar presentation. Are you ready for the June 18th PWFA rule? After receiving over 100,000 public comments on the proposed regulations, the EEOC published its final regulations and interpretive guidance implementing the Pregnant Workers Fairness Act. Taking effect June 18th, the final regulations clarify and expand upon an employer's obligation to provide reasonable accommodations under the PWFA. Before getting further into today's topic, however, I would like to take a moment to introduce myself and my organization. My name is Stephanie Zielinski, and I'm the Marketing Director of complianceHR. You may recognize my name from the email invitations that you received for today's event. To prevent a few popular questions from entering the Q&A box, I would like to let you all know that this presentation is being recorded and it will be emailed to everyone registered for the event. So please keep an eye on your inbox for an email from complianceHR webinars. Now, a bit about complianceHR for anyone who may be unfamiliar with our organization. complianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. complianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law, something we will learn a lot about during today's presentation. To achieve that goal, complianceHR offers a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many others. Today, I would like to introduce you to a few of our solutions we call the HR Leave Essentials: PolicySmart, the Reference Center, and the Document Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a policy compliance timeline, handbook checklists, and even automated emails to alert you on new legal changes going into effect. The Reference Center is a solution that combines many rapid reference topics such as final pay, FMLA, minimum wage, paid sick leave, among many others. Created to help HR, legal, and compliance professionals do their jobs more efficiently and effectively, this solution, along with all of our others, leverages data directly sourced from Littler to ensure compliant answers to critical questions. Finally, the Document Center provides you with instant, custom federal and state compliant forms and documents focused primarily on employee leave and onboarding. If you're interested in learning more, a survey should have popped up on your screen. You may have to exit full screen mode to see it. If you would like to receive a complimentary demo of the Navigator Suite, simply answer yes, and I will send your contact information to our team of experts to have a deeper conversation with you about how your compliance strategy may be streamlined and supported by the complianceHR solutions. In addition to a demonstration, you may be eligible to receive a free trial of our products so you can see precisely how much time and money they can save you. While I give you one more moment to finish up answering that poll, I'd like to share a bit more about how these solutions can support your compliance team's leave strategy. On the screen, moving from left to right, you'll see many screenshots. The first is an example of the National Employee Handbook, including the California State Supplement, which details out the policies required under the PWFA. Next is a list of available leave forms offered by our Document Center tool. Moving to the red graphic, this is an example of one of our newer reports, the Paid Sick Leave Report. This breakdown offers a side-by-side comparison of paid sick leave policies across all U.S. jurisdictions, ensuring your team can easily and compliantly implement these policies or the most stringent of them. Finally, the last image is an example of the general requirements for California's FMLA policy, including a breakdown of the federal and state eligibility. Again, if you're interested in seeing these solutions or if the information on screen might be helpful to your team, please select yes on the poll or click the link in the links panel. Now I have the pleasure of announcing today's webinar presenters, Rocio, Blanco, Garcia, and Lauren Robertson. Rocio is a shareholder in Littler's Miami office, and she counsels and represents clients in a broad range of labor and employment law matters, of course including the topic of employee leave. Lauren is a Littler's associate based out of the Orlando office with experience litigating employee leave cases among a variety of other employment law policies, making these two experts on today's topic. Lauren and Rocio, thank you so much for presenting. I will pass it over to you.
Thank you, Stephanie. Hi, everyone. Thank you so much for your time today and for your diligence in wanting to learn more about the Pregnant Workers Fairness Act and the impact of the recently enacted final regulations put out by the EEOC. For those of you who have attended our webinars before, you've probably heard me say that, Lauren and I love talking about leaves and accommodations. While we very much, like defending companies if they were to get in trouble, we prefer to keep companies from getting in trouble. And we think that education is a key aspect of being able to accomplish that goal. So for us, it is a treat to be here with you, and we hope that you will find this informative. If you are new to this type of conference, just know that there is a chat where you can pose questions. We try to incorporate as many of your questions into our presentation as we go. Many of them will be addressed as we speak, but some of them may be responded to at the end, and you may hear from one of us days later once we have been able to work our way through all the questions. We often get hundreds of questions, so please, be patient if it takes us a little bit to get back to you. But without, further ado, let's jump right in and talk about what we're here for today. So today we're going to be giving you a brief overview on the Pregnant Workers Fairness Act. The law has been in place now for almost a year, but we want to give you a refresher because the new rules are becoming effective now. Now, we also want to talk to you about distinctions between the ADA and the Pregnant Workers Fairness Act. We're going to talk about the difference between the final rules that were just put in place and the proposed rules that had been in place for about a year. And then we're also going to be touching about the interaction with other laws. So what is the Pregnant Workers Fairness Act? So the Pregnant Workers Fairness Act, as I said, took effect last year in June of 2023, June 27th to be exact. And it broadly requires employers to provide reasonable accommodations to employees for known conditions related to pregnancy, childbirth, or other related medical conditions, unless doing so will pose an undue hardship. And if you look at that sentence, you're going to see a lot of terms that you should already be familiar with, because the topic of reasonable accommodation and undue hardship, these are all things that you've heard about countless times in the context of the ADA. And as I alluded to earlier, today we're going to be talking about how this law expands on how we view these things and how we may need to be more permissive than we used to be under the ADA when we're dealing with a known condition. There's going to be an interactive process that is required, which is, again, going to look very much like the ADA interactive process. And the law also prohibits retaliation and coercion for employees who seek accommodations under the Pregnant Workers Fairness Act. Now, this law does not replace federal, state, or local laws that are more protective of applicants and employees. You still need to apply state law if the state law is more permissive. So the broader rule will apply. Somebody in the chat had asked about Texas and how the question was, Texas just recently rescinded the PWFA. Is it still enforceable? Yes, of course it is, because it is a federal law that is going to apply in all 50 states. It provides the floor, not the ceiling, so the states can do more and grant additional rights, but they cannot do less than the PWFA requires. Now, they may file a lawsuit and challenge it, but until the law goes away, it still applies. So if the law has been in effect since June of 2023, why are we talking about it now? Well, on April 15th of 2024, the Equal Employment Opportunity Commission, which you are all familiar with and investigates charges of discrimination and retaliation, issued its final regulations to carry out the Pregnant Workers Fairness Act. Now, these final regulations will be going into effect June 18th, so in a little less than a month. And the EEOC is currently accepting charges alleging violations of the Pregnant Workers Fairness Act. So what are we going to be expecting? Well, about 50% of the workforce has the ability to get pregnant or experiences one of the conditions that is covered by the Act, things like menstruation, even infertility issues. Somebody asked in the chat about IVF. Yes, that is something that is covered by the PWFA as well. So we have a large population of employees who are going to be entitled to some protections under this act. And because the act is so expensive, we do expect to see an uptick in accommodation requests. And also we expect to see an increase in charges alleging failure to accommodate under the Pregnant Workers Fairness Act. So that is why we're talking about it now. We want to make sure that you are equipped to know what you need to know. And look, we're here only for an hour, so you're not going to walk away from this training knowing everything that there is to know, but hopefully you walk away knowing enough to understand and recognize when you need to pause and ask questions and loop in your either internal or external legal team for counseling. All right, Lauren, why don't you tell us a little bit more about what we're looking at?
Yes, thanks, Rocio. So the first step to ensuring compliance is understanding who does the law apply to. The Pregnant Workers Fairness Act tracks the ADA in this regard, adopting the same definition for covered employers applying to 15 or more employees. The obligations to accommodate under the Pregnant Workers Fairness Act applies to both applicants and employees, and you'll see the term on the screen quoted qualified, and we'll touch on what it means to be qualified under the Pregnant Workers Fairness Act in the later slides. But what Rocio and I have been seeing recently, and as well as in the pre-registration sign-up questions that we received, is that companies are coming to us and telling us, oh, well, we interviewed an applicant via Zoom for a physically demanding position, and then learning upon hire that that employee is pregnant, and asking, well, can't we just terminate them? They have physical restrictions. They can't do the job. And the answer is no. It doesn't matter if the employee has been employed for 30 minutes, 3 hours, 3 days, 3 weeks, 3 months, or 3 years. The employer's duty to accommodate under the Pregnant Workers Fairness Act applies equally to applicants and employees. So if you were to receive a note or a doctor's note requesting modification of a lifting requirement from an applicant, we would be required under the Pregnant Workers Fairness Act to treat that as the same, in the same way, engaging in the interactive process as we do with employees. As Garcia mentioned, the Pregnant Workers Fairness Act requires employers to accommodate known limitations. So what does it mean to known limitation? Limitation is any physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Unlike the ADA, which requires an employee's physical or mental condition to substantially limit one or major life activities, there is no level of severity required under the Pregnant Workers Fairness Act. The limitation can be any impediment or problem that is minor or modest and can be episodic in nature, such as migraines or morning sickness. It can be that the employee or the applicant needs to take actions to protect their health or the health of their pregnancy, such as not being around certain chemicals if their job so requires, not working in the heat, or limiting and avoiding certain physical tasks, lifting, bending, walking, standing, or running. Or it could be that the employee needs to attend healthcare appointments for the pregnancy, childbirth, or related medical condition itself. Another question that we have been getting recently is, well, how far does related medical conditions extend? Meaning, does the Pregnant Workers Fairness Act require employers to provide reasonable accommodations to an employee when an employee's partner, spouse, or family member, and not the employee themselves, has a physical or mental condition related to the pregnancy, childbirth, or related medical condition associated therewith? And the answer is no. The EEOC, in its final rule, expressly recognizes the limitation must be specific to the employee in question. Like the ADA, the Pregnant Workers Fairness Act does not require an employer to accommodate an individual's association with someone else with a PWFA covered limitation or provide accommodations for bonding or childcare. As far as what does it mean to be known, a known limitation, known under the final rule is defined as actually communicated to the employer by either the employee, the applicant themselves, or their representative, or otherwise should have been aware of, such as what we call being on notice. So what does it mean, or when is an employer on notice of the need to accommodate? This largely tracks the ADA, and there are a number of different circumstances for which an employer can be on notice of an employee's or applicant's need for accommodation. There are no magic words needed to trigger the interactive process, and the request can be oral or in writing. So on the screen, you'll see that there's several different types of examples that wherein an employer is constituted to be on notice. An employee turns in a doctor's note that she has restrictions indicating they are unable to do some aspect of their job. You realize that a timesheet or hours worked looks different than usual. An employee has poor attendance and is about to lead that poor attendance is about to lead to discipline, and cites her need to attend OBGYN appointments or her nausea related to her pregnancy as reasons for the absences. An employee explains during the course of a counseling or disciplinary meeting that she is pregnant and her nausea is contributing to her inability to meet the required performance metric. Some additional examples include an employee providing information in person via telephone from a family member about a medical condition related to pregnancy that may require time off work, either on occasion or all at once. A manager notifies you that she has seen a significant change in an employee's behavior, work patterns, or conduct, and has reason to believe they may be related to the employee's high-risk pregnancy. So this begs the next question. What does it mean for a medical condition to be related to, affected by, or arising out of pregnancy, childbirth, or other related instances thereto? And the Pregnant Workers Fairness Act adopts an expansive definition. Pregnancy and childbirth refer to the pregnancy or childbirth of the specific employee. It includes current, past, present, or intended pregnancy, which is further defined as infertility, fertility treatments, and the use of contraceptions, labor itself, including childbirth, both vaginally and by cesarean section deliveries. Related medical conditions include medical conditions related to the pregnancy or childbirth of the specific employee, and to be related, the medical condition does not have to be caused solely, originally, or substantially by the pregnancy or childbirth. There are some medical conditions where the relation to pregnancy will be readily apparent. This includes medical conditions relating to termination of pregnancy, including via miscarriage, stillbirth, or abortion, ectopic pregnancy, preterm labor, pelvic prolapse, nerve injuries, preeclampsia, hyperemesis, carpal tunnel syndrome, chronic migraines, dehydration, nausea, vomiting. The list goes on, and the EEOC's list and the final rule explicitly notes this, that list is non-exhaustive. The final rule also expressly recognizes that the qualified employee does not have to specify a condition on the list in order to trigger the interactive process or use medical terms to describe the condition. The fact that the medical condition is related to the pregnancy will usually be evident when the medical condition develops, is exacerbated, or poses a new risk during an employee's current pregnancy. However, simply because a condition is limited as one may be related to a medical condition does not mean it is necessarily relates to pregnancy or childbirth. So, for example, if an employee who gave birth 2 weeks ago is vomiting because of food poisoning, that medical condition is not related to pregnancy or childbirth, and the employee is not eligible on the basis for a Pregnant Workers Fairness Act reasonable accommodation. In essence, and what makes this new law so challenging is that the final rule potentially extends the requirements to provide an accommodation, reaching virtually every condition, circumstance, or procedure that relates to any aspect of the female reproductive system. There may be steps that an employee can take to mitigate or lessen the effects of a known limitation, such as taking medication, getting extra rest, or using a reasonable accommodation. But when determining whether the employee has a limitation under the Pregnant Workers Fairness Act, the final rule explains the ameliorative or positive effects of mitigating measures, as that term is defined under the ADA, shall not be considered when determining whether the employee has a limitation. However, detrimental or non-ameliorative effects of mitigating measures, such as negative side effects of medication, the burden of following a particular treatment regimen, or complications that arise from surgery may be considered when determining if an employee has a limitation. And when it comes to determining what accommodation an employee may need, an employer may consider both the positive and the negative effects of mitigating measures. So now I'm going to flip it back to Rocio, who is going to cover some examples.
So before I do that, I do want to address the chat because I feel like the chat is on fire with menstruation. Everybody is thinking like, well, now this covers, almost all female employees. Yes, right. So the PWFA, what makes it so unique is that it's extremely expensive, and things like menstruation are expressly addressed in the final rules and in the regulation to basically, yes, you may need to accommodate those things. And Lauren just said a sentence a couple of minutes ago that said, the rule recognizes that it could be interpreted to cover almost every aspect of the female reproductive system. So yes, you do need to, if an employee comes to you and tells you, I experience debilitating cramps because of my cycle every month, that could be covered under the Pregnant Workers Fairness Act, and frankly, could have been covered also under the ADA if it rises to the level of severity that would be, required for an ADA condition. However, because the PWFA is more expensive than the ADA, you're probably going to have to go to greater lengths to accommodate that type of situation that you would have had under the ADA, and that may even require temporarily eliminating essential functions of the job, which is another thing that people are asking about on the chat. So yes, for all of you asking about whether this covers things like menstruation, yes, it does. All right, let's talk about this scenario. So Sarah is pregnant. Before pregnancy, Sarah received 2 extra breaks to eat and drink due to type 2 diabetes, which was an ADA accommodation that she was receiving. And Sarah now needs additional accommodations during pregnancy to monitor and manage diabetes more closely to avoid or minimize adverse health consequences. So yes, this is a pre-existing condition, but the Act expressly covers exacerbation of pre-existing conditions resulting from pregnancy. So now these additional breaks that she needs and these additional accommodations that she needs fall within the scope of the Pregnant Workers Fairness Act, even though it was a condition that she had before she even got pregnant. Okay, that exacerbation itself is covered under the Act. Scenario number 2, Mary has high blood pressure, which could be managed with medication prior to pregnancy. When Mary became pregnant, the high blood pressure posed a risk to Mary's pregnancy. Mary now needs bed rest. Same thing, right? This is an exacerbation of a pre-existing condition. She had high blood pressure from before. She could manage it perfectly fine before the pregnancy, but now she needs an accommodation, and that accommodation is bed rest. So we are going to have to engage with her in an interactive process under the Pregnant Workers Fairness Act. And if we need to, and we're going to talk about this in greater detail in a few minutes, but if we need to eliminate some essential functions temporarily due to the finite time of a pregnancy, we may need to do that, and we might need to let her work from her bed if that's a possibility, and if not, we might need to give her leave, with leave being an accommodation of last resort. So these are all topics that we will explore in greater depth.
And so perhaps the biggest distinction between the Pregnant Workers Fairness Act and the ADA is the definition of what it means to be a qualified employee. Employers accustomed to the ADA framework, in which the inability to perform essential functions of a job with or without a reasonable accommodation is disqualifying, will need to follow the Pregnant Workers Fairness Act's different framework carefully when evaluating accommodation requests. So under the Pregnant Workers Fairness Act, the fact that the worker is seeking a temporary suspension of an essential job function does not automatically disqualify them seeking an accommodation, as long as that person is or is expected to be able to perform the essential duties in the near future, and the employer can reasonably accommodate the inability to perform that function. If, on the other hand, there is no reasonable accommodation for the temporary suspension of an essential function, then the individual is not qualified. And similarly, if the temporary suspension of the essential function causes an undue hardship, which Rocio will touch on later, then the employer need not to provide the reasonable accommodation that includes the suspension of that job function. So what factors do we look at when determining if the inability is temporary? We look at the length of time the employee is unable to perform the essential function, whether the temporary inability can be accommodated, is there other work the employee can accomplish, the nature of the essential functions, including its frequency, whether or not there are other employees, temporary employees, or third parties who can perform or be temporarily hired to perform the essential function that is being sought to be suspended, and whether the essential function can be postponed or remain unperformed for any length of time, and if so, for how long. So, for example, if you consider the situation where an employee seeks to have an essential function suspended for 6 months, the employer can go without that function being accomplished for 4 months. Well, after that, the employer is going to need to determine whether accommodating and suspending that function for an additional 2 months will create an undue hardship. The Pregnant Workers Fairness Act does not define temporary or in the near future itself. That is defined by the final rule. And while the proposed rule applied this time limitation definition across the board, regardless of the circumstances, the final rule does not. It differs from the proposed rule with respect to how we define in certain circumstances what in the near future means. Temporary is defined as lasting for a limited time, not permanent, and may extend beyond into the near future. And in the near future for current pregnancy, the final rule further defines as generally 40 weeks from the start of the temporary suspension of an essential function. The final rule emphasizes this does not mean the essential function always must be suspended for 40 weeks, or that the employee seeking the temporary suspension is automatically guaranteed or the employer has to automatically grant a 40-week suspension. The actual length of the temporary suspension will depend on what the employer requires and if we can establish an undue hardship. As to conditions other than pregnancy, the final rule differs from the proposed rule in that the 40-week period does not apply. The EEOC opines that this is because, unlike current pregnancy, there is not a consistent measure of how long these diverse conditions can generally last. So in the near future, in these cases, will be determined on a case-by-case basis, but what we do know is that it does not mean indefinitely. And when determining on a case-by-case basis if the employee will be able to perform that function in the near future, we go back and we look at those other factors. Once the employee is able to return to work, the clock will restart. So the employer will need to consider at that point whether it can temporarily waive an essential function of the job as an accommodation, not counting leave towards any time limitation. So here is an example. Patricia is told by her healthcare provider 1 month into pregnancy, she should avoid certain chemicals for the remainder of her pregnancy. The essential function of her job is this exposure to chemicals. Patricia requests to continue her other tasks that do not require exposure to chemicals. Is Patricia a qualified employee? Well, first, let's back up. Patricia needs to avoid exposure to chemicals. That need is a physical condition related to her pregnancy. Patricia needs an adjustment or change to her work, i.e. not being exposed to the chemicals due to that limitation. Patricia has communicated this to her employer, so it is no. So if the modifications that would allow Patricia to continue to perform the essential functions of her position, such as enclosing the chemicals, providing a local exhaust vent, or providing additional personal protective gear are not effective or would cause an undue hardship, Patricia can still be qualified under the definition of the Pregnant Workers Fairness Act, which allows for the temporary suspension of an essential job function. Patricia's inability to perform the essential function is temporary. Patricia can perform the essential function of her job in the near future because she is pregnant and needs an essential function suspended for less than 40 weeks. And so with that, I'm going to flip it back to Rocio so we can talk about what types of accommodations are available under the Pregnant Workers Fairness Act.
So the sky's the limit, right? Much like under the ADA, what's going to be reasonable under the circumstances is going to depend on the industry that you're in, the type of job that the employee has, the location in terms of how many employees you have there, and how many can cover for the employee, etc. So all this that tells you is that fast rules are not gonna work. You cannot just say we don't do that. You cannot just say we do not have part-time as an option, because the whole concept of an accommodation is to create an exception to a rule that you have in place, right? So you're gonna have to be flexible. And so you are going to look, when accommodating an employee, you're going to look at a lot of the same things that you looked at in the context of the ADA. So can you provide modified light duty or an alternative assignment? Can you provide additional or more flexible breaks? And we're going to be talking about some of these accommodations in greater detail in a minute. You may need to provide adjustments to a food or drink policy. Let's say that you have a control center with lots of computers and you have a strict policy that a person cannot have any water in the control room. Well, you may need to create an exception, and the exception perhaps is that instead of being an open bottle of water, the person has, I don't know, like a Stanley type cup that won't spill out if they close it appropriately, right? So you are going to have to exhibit that type of flexibility. You may need to make facilities easier to use. At my prior job, my parking spot was really far from the entrance to the office, and if I am experiencing some sort of limitation as a result of pregnancy or childbirth that makes it difficult for me to walk that particular distance, I may need to be temporarily assigned to a parking spot that's closer to the entrance. There may also be changes to the dress code. We may need to do modified schedules, give intermittent leave or time off for appointments. Again, the sky is the limit. So this list that you see here is just a sampling of potential accommodations. It is by no means an exhaustive list, and really the law expects you to be creative, right? It expects you to really do the homework of sitting down and looking at what is my industry, what is this person's job, and what can I possibly do to accommodate this employee so that they can continue working. Now, the rules talk about this concept of predictable assessments. And these are things that we consider per se reasonable accommodations. So if you have an employee who is pregnant, it's going to be considered per se reasonable that the employee be allowed to carry water and drink or as needed in their workspace, that they be allowed to take additional bathroom breaks, that they'll be allowed to stand and sit as needed, and also additional breaks to eat and drink. So these four things are considered per se reasonable. So keep those in mind, because if you try to say, oh, we did not allow, extra restroom breaks because there were certain productivity measures that the employee needed to meet, and the bathroom breaks will have interfere with that, you are probably going to get in trouble, because these things are considered per se reasonable. And I mentioned this earlier, that leave is an accommodation of last resort. So you have a pregnant employee, or you have an employee who is experiencing one of the conditions covered by the Act. They come to you, they ask for accommodations. Your first go-to cannot be like, well, we cannot do that. You got to go on a leave, on an unpaid leave, because leave under the Act is unpaid. Now, keep in mind that in different states, there may be paid sick leave policies. There may be other disability insurance coverage that you are required to provide and give the employee notice of. But generally speaking, but just looking at the PWFA by itself, it is unpaid, right? And so the law wants to make sure that you're not just going the unpaid leave route as your first step. You are expected to first try to accommodate the employee within their current job. If not, you're going to try to reassign them. And then if everything else fails, then you provide leave as an accommodation, unless you are also not able to do that because you will be able to show that there is an undue hardship. Lauren?
Yes, so diving in deeper into what the interactive process means under the Pregnant Workers Fairness Act, when defining the interactive process, the language of the Pregnant Workers Fairness Act largely tracks the ADA. So I already covered notice in the prior slides, but as for the actual definition, it's defined similarly as an informal interactive process and states that the process should identify the known limitation, the adjustment or change at work that is needed because of that limitation, if either of these are not clear from the request itself, as well as any possible accommodations. There are no rigid steps that must be followed in the interactive process. The interactive process is supposed to be an open dialogue to ascertain the limitations of the employee and what accommodations, if any, can be provided, with the mindset under the Pregnant Workers Fairness Act that leave will be provided as an accommodation of last resort. One other major difference between the ADA and Pregnant Workers Fairness Act is that the EEOC recognizes that pregnancy is temporary in nature, so it places an affirmative reminder on employees to respond expeditiously in the interactive process, and even recognizes that in some instances, a 1-week delay in responding to a request for accommodation may violate the Pregnant Workers Fairness Act. The EEOC also highly suggests employers should consider granting accommodation even if the employer believes it needs additional information from the employee. But the rule notes that interim accommodations are not required. And as Rocio mentioned, with leave being an accommodation of last resort, requiring an employee to take leave, especially when another accommodation would exist and appropriately accommodate that employee, that may be or will be found to have violated the Pregnant Workers Fairness Act. So moving on, under what circumstances can we and can we not request supporting documentation and medical documentation from employees when requesting accommodations? And there are several circumstances in which the final rule recognizes that medical documentation cannot be requested, and that is when the need for an accommodation is so obvious that an employer has the information needed from the employee itself in the request, when the request is for one of the predictable assessments that Garcia touched on earlier, so carrying a water bottle, additional restroom breaks, standing and sitting as needed, or additional breaks to eat and drink. And when the request is for a lactation accommodation, or the accommodation would otherwise be provided without needing to provide supporting documentation under an employer's policy or practice. In these circumstances, an employee's self-confirmation...
Lauren, let me just ask you a question for the group. So, because there's a lot of questions about documentation. So let's go back to this concept of predictable assessment. And let's say that you have an employee who is, 10 weeks pregnant, not showing yet, and comes to you and tells you, oh, I need extra bathroom breaks, and I need a little bit longer lunch break, and I need, I also need to be able to carry a water bottle at all times and drink water as needed. Can you, in that situation where the employee is not showing, request medical documentation in order to confirm that the employee is pregnant? Or is the employee's statement that she's pregnant supposed to be taken at face value?
Under the EEOC's final rule, the employee's statement is supposed to be taken at face value. The EEOC's final rule expressly recognizes that an employee's self-confirmation of her pregnancy is the only thing that an employer may seek. So the answer would be no as to any additional supporting documentation.
And again, that is only for things that in this slide, right? Like the need of the accommodation is
Correct.
obvious, you're dealing with a predictable assessment, otherwise you can seek accommodation.
Correct.
Documentation.
Correct. And so when medical documentation is allowed, of course, there there are state laws that also govern when you can and cannot request medical documentation from employees. But from a broader perspective, under federal law, employers are only allowed to request supporting documentation in connection with a pregnancy accommodation request when it is reasonable under the circumstances. Reasonable under the circumstances to confirm certain information. So the physical or mental condition necessitating in the limitation, requiring the change or adjustment at work for that employee for that reason, and what possible accommodations would there be to accommodate the employee in their current role so that absent leave, so that we exhaust all avenues before needing to say, okay, well, we can't accommodate you, you're going to have to go out on leave. So for example, if an employee asks for leave as a reasonable accommodation to attend therapy appointments due to anxiety early in the employee's pregnancy, the employer could, but is not required, to ask for documentation confirming that there is a physical or mental condition that is related to, affected by, or arising out of the pregnancy, and information about how frequent and how long the leave would be. When the employer applicant has already provided the employer with sufficient information to substantiate that the worker has a known limitation, is pregnant, and needs a change or adjustment at work, it is not reasonable for an employer to require documentation. So for example, if a worker has already provided documentation stating that because of their recent cesarean section, they should not lift over 20 pounds for 2 months, the employer may require further documentation during those 2 months because the employee has already provided the employer with that sufficient information to substantiate that they have the limitation and that they need a change at work because of such. And with that being said, when does an undue hardship occur? And Rocio will explain that in further detail.
So we have been for the last 40 minutes or so telling you accommodate, you have to be creative, you have to be flexible. Well, when don't you have to accommodate? Well, you do not have to provide an accommodation if the accommodation would be an undue hardship. And just like I said at the beginning of today's presentation, that is a topic that you are all probably familiar with in the context of the ADA. So you're going to look at, in determining whether an accommodation is an undue hardship, you're going to look at many of the same factors that you did and when working under the ADA. So you're going to look at the nature and net cost of the accommodation, the financial resources of the company, although keep in mind financial resources alone will rarely be a reason to not grant an accommodation. Obviously, if we're dealing with a mom and pop shop, they're going to have a better chance of saying that there's an undue hardship than if you're dealing with a, national corporation. The number of employees plays a role, the number and type of location of the employer's facilities, and also what are the operations? What is the geographic reach? What is the ability of the employer to cover with temporary staff? So these are all things that you're going to have to consider. Now, as somebody who does this day in and day out, I'll tell you that at least a couple times a week, I get a call from an HR professional who tells me, we have an employee who has made a request for an accommodation. We asked the business, we asked the boots on the ground, the supervisors, whether we could provide that, and they said, no, we cannot do it. And inevitably, when I ask, why can't you do it? They'll say, well, they just said they have never done it before, or that, it's going to create a morale issue. Our job as lawyers, and your job also as for those of you who are human resources professionals, is to really push back because we have to protect the company. And that means that we need to have data to back up our conclusion that something is going to be an undue hardship. I cannot do much with a supervisor who just tells me we cannot do that. I want to know why. Have we ever done it before? What would you do if this employee was actually eligible for FMLA and you had no choice but to give them the leave that they're requesting? What would you do if, this employee had suffered a workers' compensation injury and they couldn't perform this particular function? How would you have managed? I want to ask those details, and I want to accumulate data that if one day I end up in litigation, I can show a judge or a jury, well, this is how we concluded that there was an undue hardship, right? So don't just take these conclusions at face value, really dig in and try to get data to have calls with the business and with different people who are in charge of the particular department to try to understand whether this would truly be an undue hardship. Now, we've talked before about this concept of leave as an accommodation under the PWFA. And many times I also hear, well, we cannot give leave because it will be an undue hardship. Who's going to cover for the employee? Well, I want you to keep in mind 6 facts or factors that can kill your undue hardship argument when you're dealing with leave as an accommodation. So if you already have a company policy that provides for leaves of that length, for example, bonding leave, if you were bonding with a child, you would have gotten, 12 weeks under FMLA, for example. Well, it's going to be very difficult for you to say that you cannot provide 12 weeks to accommodate a known limitation of pregnancy, childbirth, or a related medical condition, because you would have had to provide that type of leave if this was falling under the FMLA, for example, right? If the employee has taken leaves in the past of a similar duration without incident, it's going to be hard for you to say, well, we did it successfully in the past, but we cannot do it now. You're going to have to show that there has been some material change in circumstances to justify a departure from what you've done before without incident. If you're able to successfully cover the period of leave by having either coworkers or subordinates or even temporary staff cover for the employee, then, that can also be very detrimental to an argument that there is an undue hardship. I see this sometimes, where we terminate an employee right before or close to the time that they are expected to return. I actually had a case like this not too long ago where the employee had gotten multiple leave extensions. Then the employee said, I just need, 1 more month, submitted proof from the provider saying they only need 1 more month of leave as an accommodation, and we terminated at that point. 1 month, it's going to be, if the employee is really expected to return so quickly, it's going to be hard for you to say that there's an undue hardship there. And then a lot of times also, I get this concept of, well, we need to fill the position. We cannot do without employees, so we're going to go ahead and we're going to post the role. We're just going to deny the leave, fill the role, and move on. Well, how long does it take in your organization to replace an employee? Because my experience has been that between posting the job, going through the different candidates, selecting the best ones that you want to interview, interviewing them, onboarding them, you end up sometimes with 1-2 months before you replace the employee. So keep that in mind as well, because if the leave that the employee is requesting as an accommodation under the PWFA or even under the ADA is short enough that it's about the same that it will take you to replace that employee, it's going to be very difficult for you to say that there is an undue hardship as well. Now, I mentioned this before and I'll mention it again. You cannot forget about your state laws. For those of you who are in Florida, look, easy peasy, we're mostly just dealing with federal law all the time, right? But if you are in states like California, Massachusetts, New York, there's a multitude of very expensive leave laws, paid sick leave benefits that you have to keep in mind. You are not working with the PWFA alone. You need to keep all these other laws in mind as well. Now, another thing is you have to, a lot of times the employee will come and say, I need an accommodation. And then our mind immediately goes to like, okay, we're dealing with accommodation. We're dealing with the world of accommodations. Well, if an employee like Laura has a note from her doctor stating that she needs to work part-time while pregnant, even if she's using the word accommodation, that is just a request for leave under the FMLA, right? So because FMLA states that if you need time off for a qualifying reason, for a serious health condition, you may get that leave. So in this case, when the employee is using the word accommodation, we cannot just think of PWFA. We want to make sure that this time off, if the employee is eligible and qualifies, is also designated as leave under the FMLA, and that way the 12-week entitlement under FMLA starts to run. Okay. So don't just get caught up in words. Really think about the substance of what the employee is asking for and whether it may trigger a different law. All right, Lauren?
So just to kind of piggyback off of what Rocio was saying, the best way to ensure compliance with the Pregnant Workers Fairness Act and the interactive process is communication. Communication is key, but it's critical, but also most often forgotten. A lot of times when employees or employers come to us and ask us questions with respect to specific leave and accommodation scenarios, we find that in most instances, the professional has not had a conversation yet with the employee to understand the accommodation request, including talking it through with that employee in terms of alternative accommodations that could likewise accommodate any known limitation. And communication is not only towards the employee, but involving others when necessary. So the supervisor, manager, risk safety, but only sharing with them what is strictly necessary. So with this next example, are we required to accommodate? Celia is a factory worker whose job requires her to regularly move boxes that weigh 50 pounds. Prior to her pregnancy, Celia occasionally felt pain in her knee when she walked for extended periods of time. When Celia returns to work after giving birth, which was by cesarean section, Celia requests that for 3 months, her tasks be limited to those that do not require moving boxes of more than 30 pounds because heavier lifting could increase the risk to her health and her continued recovery from childbirth. Here, the employer would not be required to provide an accommodation for Celia's knee pain unless it was related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, and would not be required under the Pregnant Workers Fairness Act. There may be obligations under the ADA. There's also no clue on the screen here giving us any inkling that Celia has provided documentation regarding the limitation. So this is a prime example of where an employer may be permitted to ascertain more information with respect to the known limitation from the healthcare provider. And one of the questions that we've been receiving in the chat is an employer allowed to require proof that an employee is pregnant? And no. So on the slide that I covered a few slides back, documentation is only permitted for 2 inquiries, and that is one, whether the known limitation is related to pregnancy and not one of the circumstances where medical documentation or seeking medical documentation is not permitted. And also the second inquiry would be what accommodations exist that would allow the employee to perform her role. Or if the employee cannot perform a temporary function, is that inability temporary? Rocio?
All right. Scenario number 5. Jackie's position at a factory involves working with certain chemicals, which Jackie thinks is the reason she has a nagging cough and chapped skin on her hands. For the 1 year when she's nursing, Jackie seeks the accommodation of a temporary suspension of an essential function, working with the chemicals, because of the risk that the chemicals will contaminate the milk she produces. The employer provides the accommodation. After Jackie stops nursing, she no longer has any known limitations. So what do? Jackie goes back to working with chemicals, right? Like the accommodation is for the finite period of time that the employee is experiencing known limitations arising from the pregnancy, childbirth, or a related medical condition. It is not needed beyond that time. Now, a little bit of a tricky issue here is that when you look at the first bullet point, it does say that due to the exposure of the chemicals, she experiences a nagging cough and chapped skin on her hands. So this actually, could trigger still ADA and actually even workers' comp, right? So because employee is experiencing an injury as a result of exposure to something at work, you will have to notify workers' compensation of that. And also you will want to potentially, depending on the totality of the circumstances, engage the employee on an interactive process under the ADA, even beyond the PWFA issues resulting from the milk supply. Another example, and we're running out of time, so we might not be able to cover all of them, but we'll do our best. All right, ERISA works in I mentioned this to Lauren earlier, that this particular example stresses me out because the employee is being tracked so closely. But ERISA works in a fulfillment center that tracks employee productivity using personal tracking devices that monitor an employee's time on task and how long it takes an employee to complete the task. If the technology determines that an employee is spending insufficient time on task or taking too long to complete a task, the employee receives a warning, which can escalate to a reprimand and further discipline. ERISA is pregnant and, as a reasonable accommodation, is permitted to take bathroom breaks as necessary. Because the wearable technology determines that due to the approved additional bathroom breaks, ERISA is spending insufficient time on task, ERISA receives a warning. So, here, we have a need to accommodate. First, I want to call your attention, just as a matter of review of what we've learned today, to that third bullet point where it says that she's pregnant and she's permitted to take bathroom breaks as necessary. Remember, that was one of the predictable assessments for which she cannot require medical documentation, all right? So we're going to provide the bathroom breaks, but of course her productivity is going to go down, because if she has to pee every hour, the productivity is going to go down. It's just a fact. So what we will need is to adjust either the wearable technology so that it doesn't, so that the tracking is adjusted to a lower productivity level. We may need to remove the tracking device altogether, or we keep it on, but we just ignore the warnings if they are reasonably related to the time spent in the bathroom for the accommodations that the employee is receiving under the PWFA. I'm gonna skip this one because it touches on the same thing as the previous one. All right. Scenario number 8. Nora is pregnant and she drives a delivery van. Her employer uses vans that do not have air conditioning. It is summer and the temperature is over 100 degrees. Nora tells her supervisor that she's pregnant and needs a change at work because of the risk to her health and the health of her pregnancy because of the excessive heat. Her supervisor orders equipment that will help her, such as a personal cooling vest and a neck fan. While waiting for the equipment to be delivered, the employer does not have other possible work for the employee to do. So what do we do? All right, let's take aside the fact that we all know that with Amazon Prime, probably the equipment is going to be here in 2 hours. But let's assume that it's going to take longer for the equipment to get here. If we don't have any other work for the employee to do, and we cannot reassign her to another position temporarily, then what we do is we give the employee leave as an accommodation. Remember, that's accommodation of last resort under the PWFA. While the equipment arrives, that's the interim accommodation, and then we put the employee back to work once the equipment that will allow her to perform the job safely is available to us. Final reminders, Lauren?
Yeah, so here on the slide, we put together just a quick graphic of the final reminders. The similarities is between the two laws is that reasonable accommodation and undue hardship definitions are track. But between the distinctions between the ADA and Pregnant Workers Fairness Act is the temporary suspension of an essential job function, the temporary nature of pregnancy requiring, more expedited response to reasonable accommodation requests, and that the fact that leave should be provided as a accommodation of last resort.
All right. I think we're, Stephanie, do you want to do the sign up for the demo part?
Sure, absolutely. So everyone, I did push out another poll if you're interested in receiving a demonstration and potentially a free trial of the complianceHR solutions. Please select yes on the poll. If you're currently watching this in full screen mode, you may have to exit full screen mode in order to see the poll. But our tools are designed to provide you with comprehensive guidance on all sorts of policies, especially like PWFA, which is so complex and difficult to understand, as many of you have mentioned in the question box. We received over 500 questions to the Q&A box today. Rocio and Lauren, do you want to answer any of those, or should we just hope that everybody has a great afternoon?
I'll answer one that I was actually in the process of typing. I saw a few people in connection with scenario number 8 ask whether that interim time that she's only spending arrival of the equipment, of the fan and other equipment that will allow the employee to withstand the heat in the vehicle arrives, if that time needs to be paid. So not under the PWFA. So the PWFA does not provide for paid leave. However, depending on the state that you're in, you may be subject to paid sick leave laws and other laws that do require payment. So for those states where you're only operating under federal law, like Florida, Georgia, then you are fine. But if you are in a state like California, New York, Massachusetts, and many others, then you need to look at the sick leave laws and other state laws that may provide for payment outside and beyond anything that the PWFA requires. All right, I think we're out of time. We want to be respectful of the fact that this is supposed to be only 1 hour. As Stephanie said, we have over 500 questions. We will get this emailed to us, and we will do our best to get back to each of you. It may take us a little bit of time to work our way through all the questions, but thank you so very much for being engaged, for being here, and we hope to see you at the next one.